Paging Aitken Robertson to courtroom number 2. The jury is back with a verdict. Members of the jury, how do you find the accused? Guilty or not guilty?
Not guilty on all accounts, Your Honor.
Welcome back to Legally Speaking, your YouTube channel brought to you by Aitken Robertson. I'm Melanie van Aarde, your host and paralegal at Aitken Robertson. Today we are delving into a crucial topic. What to do if you're facing a no-contact release term and the complainant continues to contact you. Joining us today to shed some light on this matter is our esteemed counsel, Richard Aitken. Richard, we have had domestic assault cases before where one of the problems is that our client's ex is trying to get a hold of them. How would you recommend them handling this situation?
It's going to be a real problem because if the accused gets charged and convicted of a breach, even though it's not a breach they initially caused, the starting point is 30 days in jail for each breach. So I'll give you some examples, and Mel, of course, you're well aware of them, but for the benefit of our audience, sometimes in a domestic, the party who calls the police has second thoughts and wants to basically get back together again. So in a more typical situation, they might call on telephone or text or email or do something on social media to try and contact your former partner. Problem, of course, is one, it's a breach and a dangerous breach. And secondly, that if they do reunite, often what happens is a further argument. The one spouse who originally called the police calls the police again. Our client gets arrested and has problems getting bail second time around.
So one of the terms that we usually see in an undertaking or a release order would be no direct or indirect contact. Can you give us examples of what these types of contacts would mean?
Sure. Direct is the more obvious one, that you talk to a person in person or on telephone or through social media, one-to-one contact. Indirect is more like passing messages. You're asking your parents to call your partner from before, that perhaps you have a mutual friend, something of that nature. Both are equally are breaches, and both will land you in jail.
And then let's say the complainant still persists. Certainly over the years, I've seen a few examples of one spouse being a party to the breach, even though they were the victim in the alleged criminal complaint.
Possible that the actual prior victim gets charged with the breach as well, being a party to the breach. In other words, if, say, they won't let go and keep on trying to contact the accused person despite being warned by the police, sooner or later the police lose their patience and charge the person as a party to the breach, where basically they're charged with aiding and abetting the breach and could end up in jail themselves.
So what about your general advice? Should that continue to our clients?
Call your lawyer, and the lawyer will give you advice about whether or not you should speak to the police. The important thing is to document what happened, be able to prove conclusively that you're the one who's being stalked or harassed. So you may have surveillance video that's time-stamped, cell phone records are time-stamped, emails have timestamps on them. Any information you get from your former partner, screenshot it or save to social media or otherwise capture the evidence, as it'll be useful later on. Keep in mind, even if they're the ones who call you and say, "Hi, Bill, how are things going?" If you say, "Hi, Denise," fine for me, that's a breach. But you didn't cause it. I understand that. But you communicated once you were aware of who it was. You can't even say, "I can't talk to you." You simply hang up.
And are there any preemptive measures that the accused can take and implement to address the situation?
Sure. I think one of the more obvious one, just to be careful to avoid pocket dialing, is to unfriend the person, take them off your social media, take them off your contact list, block them. In serious situations, if you're being harassed, consider changing your phone number. In situations where you think you're at risk, perhaps moving.
And would you say that putting up video cameras would be a good move as well?
Video cameras are so inexpensive these days for most people. It's a good idea. If you do it, you want to get cameras that are fairly discreet and not obvious. Many people have cameras at their doors, which work well, but any kind of camera, especially if it's secret, is fine. The other thing to keep in mind, the law in Ontario is for taping of conversations, so long as one person consents, it is legal. So if someone calls you, it's okay to tape it. Just make sure you don't talk back to them. You could certainly preserve the communication, but don't talk or encourage or do anything to carry on with the conversation or the contact, however.
Richard, what potential repercussions could arise if an accused actually engages in the communications with the complainant and thereby violating their release terms?
I just take it really seriously. So on a first breach, you can anticipate your bail being harsher. If you have a previous record, including breaches, you may have problems getting bail. If this is the second time around for a breach, you may have problems getting bail at all. You may need a surety. You may need a second surety, or you may not get bail at all. And you could be in custody until either you pled guilty, you've been acquitted, or you've been sent.
Thank you so much, Richard, for joining us today. And thank you to everyone else for joining us on the Legally Speaking Aitken Robertson YouTube channel. Don't forget to like, subscribe, and hit that notification bell so you never miss another video. Until next time, stay informed, stay engaged, take care. Thank you for tuning in to Legally Speaking, proudly brought to you by Aitken Robertson Criminal Defence. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website or by using the QR codes on your screen now. For legal assistance, call us today or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.